Now that we've covered course structure and logistics, let's talk about course coverage. This fall we will cover Constitutional Law 1. In the spring we cover Constitutional Law 2. I think of Constitutional Law 1 as a structural course. It mostly concerns the structure, function, and powers of our government. Some people consider this the most boring part of con law, with the sexy part being personal liberty interests and freedoms of speech and religion. We cover personal liberty interests, including those arising under due process and equal protection, in depth in Constitutional Law 2 in the spring. At the end of the spring, we'll touch very briefly on the First Amendment, really just as a teaser should you decide to go on to take specialized courses offered on the First Amendment. I happen to think structural constitutional law is the sexiest of all. Well, maybe that's a bit hyperbolic, but the truth is that the separation of powers and the relationship between the federal and state governments is at the core of what makes the American experiment unique. These questions also are at the core of many of our most important political disputes today, even as they relate to the issues of due process and equal protection we cover in the spring. Also, for most of you, in your day-to-day practice, the vast bulk of your interaction with constitutional law will reflect issues of constitutional structure. In particular, if you're a litigator, you'll deal with questions of judicial power every day. In my specialty of cybersecurity law, for example, one of the hottest issues today is whether consumers have constitutional standing to bring private actions for data breaches, an issue about which there currently is a circuit split. It doesn't sound sexy, but billions of dollars ride on it, and the doctrinal resources are subtle and more than a bit fuzzy. Also, the legislative power, including in relation to seemingly really dull stuff, such as Congress's power to tax and spend, has also been at the forefront of contemporary issues, including, for example, the ongoing debates and litigation over Obamacare. And of course, whatever side of the political aisle you sit on, and whatever your personal view of President Trump, there's no denying that his presidency has brought many long-simmering questions about the scope of executive power to the boil. But one of the hottest battlegrounds in recent decades, believe it or not, has been the scope of the commerce power, the dormant commerce clause, and related notions such as the anti-commandeering doctrine. The recent Supreme Court decision that allowed for legal sports betting in New Jersey and other states is an example of these principles in action. Don't worry, you shouldn't expect to know these doctrines yet, but you'll learn them and see why they're so important before the semester is over. Let's talk for a moment about the basic structure established in the Constitution. Some of this will probably be vaguely familiar if you learned it in a basic high school or college civics class. The first thing to recall is the background of the Constitution, as drafted by the Constitutional Convention in 1787, ratified by the states in 1788, and made effective on March 4, 1789. The states that made up the United States at that time originally were colonies of England. The colonies had joined together in rebellion against England for the reasons stated in the Declaration of Independence, as well as for other political and sociological reasons debated by historians. The Revolutionary War was effectively concluded with the Battle of Yorktown in 1781. The Treaty of Paris, formally granting the American colonies their independence, was signed on September 3, 1783. During the Revolutionary War, the Continental Congress adopted the Articles of Confederation, which were not formally ratified until 1781. The Articles of Confederation provided for only a limited central government. It often reads more like a treaty than a constitution. Article 2, for example, states that each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right, which is not by this confederation expressly delegated to the United States and Congress assembled. Article 3 states that the said states hereby severally enter into a firm league of friendship with each other for their common defense, the security of their liberties, and their mutual and general welfare, binding themselves to assist each other against all force offered to or attacks made upon them, or any of them on account of religion, sovereignty, trade, or any other pretense whatever. The Articles did, however, leave foreign relations powers such as treaty making and war to the Central Congress. Congress could request money from the states to help fund the Continental Army and other central functions, but it lacked a power of taxation or any ability to regulate foreign trade or interstate commerce as against the states. The weaknesses of the central government in the Articles of Confederation left the United States vulnerable to internal trade wars and rebellions, such as Shays' Rebellion in Massachusetts in 1786 to 1787, and external threats such as piracy on the high seas. These tensions led to the movement that produced the new Constitution, establishing a stronger central government. Advocates of the new Constitution were called Federalists. Three of them, Alexander Hamilton, James Madison, and John Jay, left behind a collection of articles and essays published in newspapers called the Federalist Papers, which are sometimes cited in Supreme Court opinions as evidence of the purpose of the new Constitution. The Federalists were opposed by critics of a strong central government, generally called anti-Federalists. As we know, Federalist arguments ultimately carried the day, but not without compromise. One of the most significant compromises was that promises were made to anti-Federalists in some states that the Constitution would be amended with a Bill of Rights shortly after ratification. The first 10 amendments to the Constitution, written by James Madison, comprise this Bill of Rights. It contains familiar substantive guarantees, such as the freedom of speech, the right to bear arms, and freedom from unreasonable searches and seizures. It also contains less familiar provisions that will feature in some of our discussions this semester, including the 10th Amendment's reservation of powers. Madison, in fact, originally proposed 17 amendments, which were approved by the House, but only 12 were approved by the Senate, and only 10 were ratified by the states, with the final necessary approval coming from Virginia in 1791. As of today, there are a total of 27 amendments to the Constitution. After the Bill of Rights, the 11th Amendment, ratified in 1795, relates to sovereign immunity. The 12th Amendment, ratified in 1804, relates to presidential election procedures. The 13th, 14th, and 15th Amendments, ratified in 1865, 1868, and 1870, are the post-Civil War amendments. Other amendments relate to, for example, prohibition and the repeal of prohibition, that's the 18th and 21st, ratified in 1919 and 1933, respectively. Women's suffrage, the 19th, ratified in 1920. Presidential terms and term limits, the 20th and 22nd, ratified in 1933 and 1951, respectively. Voting age, the 26th, ratified in 1971, and other matters. The first three articles of the 1789 Constitution establish the three branches of our federal government. Article 1 establishes the legislative power, Article 2 the executive power, and Article 3 the judicial power. We could say that these three articles establish a horizontal relationship among the three branches of government. Notice also that Article 1 established a bicameral legislature with enumerated powers comprised of a Senate and a House of Representatives. That Article 2 vests the executive power in a president, and that Article 3 vests the judicial power in one Supreme Court and such inferior courts as the Congress may from time to time ordain and establish. We'll come back to many details of these articles as we work through this semester. Article 4 is a federalism article that addresses what we could call a vertical axis between the federal government and the various state governments, as well as a horizontal axis among the various state governments. Again, we'll come back to some of the details in Article 4 during the semester. Article 5 establishes the procedure for constitutional amendments, which, you will note, is intentionally difficult. Article 6 includes provisions on prior debts incurred under the Articles of Confederation, the supremacy of national law, and oaths of office. We'll start discussing the Supremacy Clause in Unit 1. Article 7 supplies the procedures for ratification of the Constitution. We can't conclude this discussion of constitutional structure without noting America's national original sin, black slavery. Many of the Founding Fathers, including Thomas Jefferson, who drafted the Declaration of Independence, James Madison, who drafted the Bill of Rights, and George Washington, owned black slaves. Jefferson, Madison, Washington, and others sometimes expressed sentiments against slavery, but nevertheless they continued to own slaves. At the time of the Constitutional Convention, slavery existed in northern states and had become particularly entrenched in the southern states. Delegates to the Constitutional Convention disagreed about how slaves should be counted for the purposes of taxation and congressional representation. The legality of the ongoing Atlantic slave trade, that is, the importation of new slaves into North America and not the status of existing slaves, and the return of runaway slaves to their owners from northern territories. The 3/5 clause in Article 1, Section 2, Clause 3 was a compromise on how slaves were counted. It gave Southern states disproportionate representation in relation to their potential tax obligations. Defending this clause against critics who thought it would give Southern states too much power, James Madison said in the Federalist Paper No. 54 that the federal Constitution decides with great propriety on the case of our slaves when it views them in the mixed character of persons and of property. This, in fact, is their true character. Article 1, Section 9, Clause 1 prohibited Congress from enacting any legislation banning the transatlantic slave trade until 1808. Notice how that clause is worded in terms of the state's power to permit the migration or importation of persons the state thinks shall be proper to admit, again, sidestepping or ignoring the personhood of the slave. Article 4, Section 2, Clause 3, the Fugitive Slave Clause, required free states to return runaway slaves to their owners. These compromises ultimately contributed to the instability that led to the Civil War. Although they were modified by the post-Civil War amendments, the legacy of structural racism continues to haunt us. We should also note that neither the 1789 Constitution nor the Bill of Rights granted political representation to women. As mentioned, a constitutional guarantee of women's suffrage was only conferred under the 19th Amendment, ratified in 1920. This very brief summary obviously does not even begin to capture the historical nuance and drama behind the drafting and ratification of the 1789 Constitution, the Bill of Rights, or the subsequent amendments. As we focus on specific constitutional provisions and their interpretation throughout this year, we'll see how this history, as well as the immediate context in which cases are decided, can bear on constitutional interpretation and doctrine. As you consider this history and the Constitution itself, reflect on the prompt for this week's discussion forum, which we'll revisit when we meet in person. Is it true that the legitimacy of any government, including ours, is established finally at the end of a barrel of a gun? Or is it possible for a system of government and a concept of the rule of law to embody, as St. Augustine suggested, a commonwealth of people dedicated to shared higher principles?